have the gavel today? Well, good afternoon. I'd like to welcome everyone to the Higher Education Committee. The time is now 1:38, and I appreciate everyone's time and patience. Thank you. Welcome everyone to the Assembly Higher Education Committee, and welcome to the first of two policy hearings on Senate bills by the Assembly Higher Education Committee. Whether you're here in person or watching virtually, I welcome each and every one of you. I will now go over some key elements of the structure of today's hearing. As we proceed with the witnesses and public comment, I want to make sure everyone understands that the Assembly has rules to ensure we maintain order and run an efficient and fair hearing. We apply these rules consistently to all people who participate in our proceedings, regardless of the viewpoint they express. In order to facilitate the goal of hearing as much from the public within the time limits that we have, we will not permit conduct that disrupts, disturbs, or otherwise impedes the orderly conduct of legislative proceedings. We will not accept disruptive behavior or behavior that incites or threatens violence. As you came into the hearing room today, the sergeants directed your attention to the rules for public attendance and participation, which are posted outside the door. The rules for today's hearing include no talking or loud noises from the audience. Public comment may be provided only at the designated time and place and as permitted by the chair. Public comment must relate to the subject or bills being discussed today, and no engaging in conduct that disrupts, disturbs, or otherwise impedes the orderly conduct of this hearing. Please be aware of the relations enforcement actions. Additionally, please note that while this hearing will not have phone testimony, we are accepting written testimony through the position letter portal on the committee's website at www.ahed.assembly.ca.gov. Bills will be taken up and signed in order. Our committee members typically will present their bills after non-committee members. Authors, you can sign in at the sergeant's desk in room 126. Further, please note that the guideline for bills heard in this committee is to allow for testimony from 2 lead witnesses in support and 2 leading witnesses in opposition to speak for no more than 2 minutes each. Stakeholder groups and entities that are neither in support nor in opposition will be allowed to give testimony for no more than 2 minutes when a call for tweeners. If a measure has more than 2 entities in the tweener category, only 2 would be allowed to speak for 2 minutes each. Colleagues, for members of this committee, since our hearings are public and some travel far to be here, respect of them and the author, please allow the author to complete their opening remarks regarding the bill before making a motion so that the public has an idea of what the bill is about. If a motion is made during the author's opening remarks, I'll simply state that the motion will be recognized at the appropriate time. Additionally, members, if you would like to respond to a roll call, ask a question, or provide a comment, please be sure to activate your microphone and speak into your mic. For authors of bills up today, each member presenting today will have an opening and closing statement. As previously stated, your 2 lead witnesses will each have 2 minutes each to provide testimony. And at this time, Madam Secretary, roll call, please. We're going to establish quorum. Thank you. Thank you, colleagues.
Fong,
Here.
DeMaio, Berner, Jeff Gonzalez, Jackson, Marsucci, Patel, Celeste Rodriguez, Sharp Collins, Tongipa.
We have quorum. Thank you so much. 8 members present. Thank you so much, colleagues. And before we proceed to the first author, let's take up the consent calendar at this time. We have 2 bills on the consent calendar, and they are file item number 2, SB 67 by Senator Sayarto, and file item number 6, SB 619, Senate Committee on Education Omnibus Bill. Is there a motion and then a second? Moved by Vice Chair DeMaio, second by Dr. Patel. Any comments or questions? Seeing none, Madam Secretary, roll call, please.
The consent calendar consists of file item 2, SB 67. The motion is due pass to the Military and Veterans Affairs Committee. And file item number 6, SB 619, and the motion is due pass to the Appropriations Committee. Fong?
Aye.
Fong, aye. DeMaio? Aye. DeMaio, aye. Berner? Jeff Gonzalez? Aye. Jeff Gonzalez, aye. Jackson? Aye. Jackson, aye. Marsucci? Patel? Aye. Patel, aye. Celeste Rodriguez? Aye. Celeste Rodriguez, aye. Sharp Collins? Aye. Sharp Collins, aye. Tongipa? Aye. Tongipa, aye.
That measure is 8 ayes. We'll keep the roll call members added on. The consent calendar is out. Thank you so much, colleagues. First up, we'd like to welcome Senator Weber Pearson, presenting item number 1. Welcome, Senator Weber Pearson, SB 437. The floor is yours.
Well, good afternoon, Chair and members of this committee. I want to start by thanking you all so much for hearing this bill and your assistance with this bill. We will be accepting the committee amendments. As Chair of the California Legislative Black Caucus, I am here to present one of the CLBC priority bills in our 2025 Road to Repair bill package, SB 437. SB 437 directs the California State University system to identify a fair, evidence-based, and community-trusted method to determine whether an individual is a descendant of someone enslaved in the United States under the system of American chattel slavery. A little background on how we arrived at SB 437. In 2020, California passed Assembly Bill 3121, establishing the California Reparations Task Force. The task force was charged with the monumental and historic responsibility of studying the enduring impacts of slavery and systemic discrimination that endured afterwards. Through public testimony, research, and historical analysis, the task force released a comprehensive report that laid out recommendations to remedy the structural harms still felt by Californians today, from disparities in income to education, health, home ownership, and criminal justice. Among the many important and accessible process to verify lineage. Because for any reparative framework to function fairly and effectively, there must be clarity on who qualifies as a descendant of those directly harmed by slavery and its aftermath. SB 437 addresses a critical gap that remains following the recommendations of the California Reparations Task Force. The task force clearly identified that those who are descendants of slaves should be the ones eligible for any reparative benefits if and when that time comes. However, the question of how to trace lineage in a fair, accurate, and consistent way was left unanswered. SB 437 begins the process of addressing that need. For many who are descendants of someone who is enslaved, tracing ancestry is incredibly difficult. Families were separated, names were changed or lost, records were destroyed, ignored, or never created. For individuals who were adopted, placed in foster care, or who do not know their biological parents, this can feel impossible. Asking for people to navigate this process without support, structure, or guidance only adds to the injustice they have already faced. This is why SB 437 calls on the California State University system to take the lead in determining the best practices for verifying lineage. CSU is a trusted public institution with the academic credibility, research capacity, and historical knowledge needed to carry out this work with integrity. It is also a system deeply rooted in communities across California, making it well-positioned to understand the diverse experiences of the people this process will serve. The CSU system is also encouraged to collaborate with others, including nonprofit organizations, credible genealogists, and other colleagues or universities. The goal is to draw on the best thinking, experience, and resources available to determine practices that are accurate and efficient. SB 437 also gives CSU 3 years to complete the important work. During that time, the system is required to report back to the California Legislative Black Caucus every year. This ensures that this process remains transparent, accountable, and that the process is shaped with oversight and input from the communities it's intended to serve. SB 437 is supported by the CSU, Office of the Chancellor, the Greater Sacramento Urban League, Equality California, members of the California Reparations Task Force, and numerous grassroots community organizations. With me today, I have Don Tomatsky, a former member of the California Reparations Task Force, and Tanisha Herring, Government Relations Specialist for the NAACP California and Hawaii.
Thank you so much. Welcome.
Good afternoon, Chair Fong, members of the Higher Education Committee. My name is Don Tamaki. I'm an attorney with Manami Tamaki LLP in San Francisco, and I served as one of the members of the California Reparations Task Force. I'm also part of the multiracial statewide coalition the Alliance for Reparations, Reconciliation, and Truth. As the legislature recognized when it created the task force, while the enslavement of African Americans was the nation's original sin, emancipation did not bring an end to the atrocities and deprivations brought against them. Through lynching, Jim Crow laws, racist policing, disenfranchisement, segregation, redlining, and erasure of history, government at all levels perpetuated the legacy of slavery. Mass enslavement ended in 1865, but its badges and incidents have not. Descendants of those enslaved have carried the weight of these harms as trauma and loss have passed from generation to generation, resulting in huge and growing disparities in every metric that matters, from health to wealth. With respect to two essential forms of reparations, compensation and restitution, the task force recommended that eligibility be based upon lineage, requiring an individual to be a descendant of a chattel enslaved person or of a free Black person living in the United States prior to the end of the 19th century. SB 437 will provide the missing details of this complex recommendation by enlisting the CSU and universities it partners with to establish a consistent, a vetted, a fair, a credible, and an accountable process to verify lineage based upon genealogical research and grounded in scholarship and historical accuracy. We urge your support.
Thank you so much. Welcome.
Thank you. Good afternoon, Chair and committee members. I am Tanisha Herring, and on behalf of the California-Hawaii State Conference and the NAACP's 50-plus branches and 23 youth units, I'm here to express our strong support for SB 437. This bill is a critical piece of legislation that builds on the work of the California Reparations Task Force, which called for the establishment of a clear and fair process for verifying descendants of enslaved individuals. This bill provides an accurate way of determining lineage, ensuring that those who are descendants of American slavery can access reparative benefits that they deserve. This bill provides an the bill also directs the California State University System, CSUs, to create and implement a genealogy verification process. This approach not only adheres to the high standards of evidence-based research, but also prevents misidentification and guarantees that reparative benefits are directed to those most impacted by the long-lasting effects of slavery and systemic racism. SB 437 ensures that we do not leave anyone behind in this vital journey toward reparative justice. Moreover, SB 437 includes provisions for transparent oversight through annual reporting, ensuring that the public and lawmakers remain informed of the progress, challenges, and outcomes relating to the findings from the CSUs. The NAACP California-Hawaii State Conference strongly believes that SB 437 is a necessary and thoughtful next step toward addressing the historical and ongoing impacts of slavery in California. It is a forward-looking bill that acknowledges the needs of descendants while maintaining a high standard of accuracy and fairness in the verification process. And I respectfully urge that you guys help move this along in the legislative process. Thank you.
Thank you so much. Are there witnesses in support in the hearing room?
Good afternoon, Chair, members, and staff. DeBray Sanders with Kalos, California, on behalf of the Alliance for Reparations, Reconciliation, and Truth, and strong support.
Thank you.
Thank you, Mr. Chair and members. Chris Morales here with the CSU Office of the Chancellor in support.
Thank you.
Greg Polster on behalf of Equality California in support.
Thank you.
Monet Jennings on behalf of the Greater Sacramento Urban League in support. Thank you.
Thank you.
Maxwell Drawdy, Western Center on Law and Poverty, in support.
Thank you.
My name is Kidir Gukunga and I support.
Thank you. Are there witnesses in opposition in the hearing room? Welcome.
Good afternoon, Assembly members. My name is Michael Willis. I'm a professional genealogist with 24 years experience and author of the published book, When Your Ancestors Choose You, Finding Binky. SB 437 aims to have the CSUs develop a methodology for genealogical research because the author of the bill claims the task force report did not state how to accurately determine a person's lineage. That's because during its hearings, the task force relied on the witness testimonies of several genealogists, not CSUs, who presented the same methodologies that the author's last witness in the last hearing, Rachel Shaw, a professional genealogist, not a CSU student, stated conforms to the Board of Certified Genealogists genealogy proof standards. Shaw also mentioned that consultation and coordination with the African American Genealogical Society should be the key part of this process. Well, I'm the board chair of the African American Genealogy Society of Northern California. The task force final report called for the creation of a genealogy office that relied on expert genealogical research to confirm eligibility. Obviously, they were convinced that genealogists have the expertise, not CSUs researching how to do it. How do you think that the CSUs will rely on the advice and direction of their research? And if they don't, the integrity of that research must be certainly questioned. Additionally, the concerns raised about the difficulty of tracing enslaved ancestors is null and void when you consider the fact that the task force only required an individual's ancestors who lived in the United States prior to 1900. That means researching federal documents where African Americans are well documented. We are not researching enslaved people by then because they're free. SB 437 in its current form does not serve the purpose that the task force set out to achieve. It is performative at best and stalls a proven process to reparations. Our ancestors deserve better and depend on us to get this right. Thank you.
Thank you. Welcome.
Welcome. Thank you for the welcome. Good morning, good afternoon, chair and members. My name is Chris Lodge, and I'm here on behalf of the Coalition for a Just and Equitable California, the state's original grassroots reparations advocacy organization. And we strongly oppose SB 437 and urge you to vote no or abstain from voting on this seriously flawed and misguided proposal. On its face, SB 437 would allocate millions of taxpayer dollars to the California State University system to study genealogy. While this may sound helpful, in reality, genealogy study is unnecessary. In addition, this proposal misinterprets and even contradicts the very recommendations of California's own reparations task force, and in all likelihood, SB 437 will create serious implementation delays and other problems. Let me elaborate. First, genealogy is not a mystery that needs to be studied before it can be applied. Genealogy, specifically how to trace lineage back to U.S. chattel slavery, is a well-known process practiced by professionals every day. You just heard from one of the most respected genealogists from one of the leading genealogy organizations in the state tell you that this genealogy study is unnecessary. Need I say more? Well, I will, because not only is this study unnecessary, California's own reparations task force was clear. The state, working with genealogists, must provide residents with genealogy research services directly. SB 437 does not do this. Instead, it slows that process down by funding a vague academic exploration of how such genealogy services might work, with no requirement to deliver anything to the people and no requirement for the results of the study to even be used at all. Thirdly, SB 437 not only delays residents from getting direct genealogy services for at least 3 to 5 years, but it also potentially delays any and every state policy or program now or in the future for descendants, whether they are related to reparations or not. Moreover, the study proposed in SB 437 directly conflicts with what is proposed in its companion bill, SB 518, another bill that allows for a separate genealogy criteria and a separate genealogy process to be created, one that is different from what is being proposed in SB 437, introducing redundancy, confusion, inefficiency, more bureaucracy, and quite frankly, members, wasting taxpayer money. California doesn't need more reparations studies. It's time to act. Vote no or don't vote on SB 437. Thank you.
Thank you. Are there witnesses in opposition in the hearing room?
My name is Shamir Washington. I urge you to vote no in strong opposition. Thank you.
Thank you.
My name's Molly Lyon. I urge you to vote no on this proposition.
Thank you.
Good afternoon. My name is Rashad, and I'm in strong opposition. Thank you.
Thank you.
I'm Bernice Singh with Legal Services for Prisoners with Children. I'm in opposition.
Thank you.
Rose LaValle in strong opposition. Thank you.
Thank you.
Kim Mims, Coalition for a Just and Equitable California, ARC Sacramento, and ETM Media in opposition to SB 437. Vote no.
Thank you.
Yesenia Thomas with the Anti-Recidivism Coalition in strong opposition.
Thank you.
Yes, good afternoon. Darlene Crumity, member of CJEC, as well as the Coalition for California Arc Bay Area. I am actually begging you to vote no on this, as well as the Lineage Equity and Advancement Project and the California Black Lineage Society, CLBC. We respectfully ask you to vote no.
Thank you.
Carmen Munoz with the Anti-Recidivism Coalition, strongly opposing no.
Thank you. Are there tweeners in the hearing room? Colleagues, any questions or comments? Seeing none, do we have oh, I'm sorry, Dr. Sharp Collins.
Hello. I would like to thank the author for bringing forth the bill. As a proud co-author of this bill, I am in strong support of providing up to $6 million to the CSU to carry out critical research that is tied to the California Reparations Task Force. What I want to do is, I want us to be clear that the work of the Reparations Task Force, yes, it was historic, but it was only the beginning of the work that we still have to continue to do. One of the most urgent next steps is to build a fair, transparent, and accurate system for confirming who qualifies as a descendant of those that were enslaved here within the U.S. And that work hasn't been done, and it hasn't been done by most states at all, and certainly not at a scale that's necessary to really support policy that is rooted in true justice. So this work will lay the foundation for how we can confirm the true descendant status, but also guide statewide implementation and ensure the promise of reparation is built on truth, data, but also justice. So the reality is that many of our Black families truly cannot trace their lineage due to generations of stolen records, frustrated histories, well, fractured history, honestly, but also systemic system that was really error sure, meaning that it hasn't been truly accurate. So if we fail to create a process grounded in rigorous genealogy research, then we truly risk the undermining of the very goals of reparations and trying to do true sort of justice based on the historical truth, which is what we're asking for. So I'm sitting here saying that I will be going up supporting the bill today, and I'm saying that we need to fund the research so we can uplift the truth and move closer to the equity that our communities truly deserve. And this bill, it is a start, and so I will be supporting the bill today.
Thank you so much, Assemblor Sharp Collins. Assemblor Rodriguez.
If I could just ask, and feel free, the co-authors that are on this committee or the author, to respond to some of the statements by the opposition regarding there already being an established process in genealogy, as well as any delays this might cause for the other efforts.
Yeah, thank you. Thank you so much for that question. You know, I wish it was that simple. We have been trying to trace my lineage for years, and we have been unsuccessful. It may be easier for some than it is for others, but we still haven't found my lineage, right? It is extremely difficult because of the way in which chattel slavery was done here in America, where you had individuals who were torn from their families, sent to different plantations. Individuals were used as breeders. So you may have never even been around your family before. We were forced to take the names of those who enslaved us. And those records, as I stated in the beginning, are fractured if they were ever there. Some were burned. It's not as easy of a process as some would like to make it seem. This is not another study bill. This is not looking to determine if this is an important process. This is ensuring that whatever process is in place is accurate and works for everyone. Whether you can trace your ancestors back or whether you only know who your parents are, or maybe not even that at all. And so, this is extremely important. I wish that the task force had time to really dig deep to find out the methodology that we should use. Additionally, if people actually read the bill, it does also grant the CSU the ability to work with genealogists to determine the best methodology. And once that methodology is determined, then that can be used by the agency once that is in place. Now, the question of whether or not this bill must go forward for any of the other priority bills that we have or any of the other reparation bills is a false statement and is untrue. We have not linked our bill to any other bill, and none of the other authors have linked their bill specifically to us. In regards to SB 518, we have actually submitted clarifying language through amendments to ensure that it is known that there is no linkage. You do not have to necessarily pass this one. However, when you start talking about reparative work, per the task force, you have to ensure that you are a descendant of American chattel slavery. And so there needs to be a process in place to determine if you truly are.
Thank you so much. Any further questions or comments? So someone talking about.
Yeah, just want to say thank you all for being here, first and foremost. So as the genealogist, I just wanted to ask what areas, because it seemed like your argument was argument of duplicity on already redundant studies. So what processes are in place? What have you done as a professional genealogist? And I mean, in your general response.
Thank you. First, I brought this book to show you, this book has been around for almost 30 years. This is the professional proof standards that, as I stated, the Board of Certified Professional Genealogists have defined in this book, proven genealogical, proof standards that have been around. So we've been teaching these methodologies for decades. So that's number one. Number two, me personally, like I said, I've been a genealogist for 24 years. I have taken on several clients. I have trained and given presentations and seminars to hundreds of people, showing them how this can be done. I'm sorry that Senator Weber Pearson is unable to trace her particular ancestry, but there are hundreds of people who are tracing their ancestors every day. And might I add that, again, the task force community of eligibility was defined as any living person in the United States who descends from a chattel enslaved person or a free person of color living anywhere in the United States prior to 1900. So if you have an ancestor who is, let's say, you find them on a 1900 census and they're 59 years old, they're obviously born before slavery. Where do you get in? Oh, she keeps mentioning slave records and not being able, and things are unavailable and the names of the slaves got changed. None of that applies in this situation because we are literally researching free people, not enslaved. We're not digging into courthouse records. We're not looking at probates and wills, last wills and testaments where you're seeing hundreds of people enslaved with values behind their names. We're not looking at that. We don't have to go that far. The burden of proof is a lot less than that. So if that's the case, I don't understand how we get to this point where we have to rely on the CSUs to do the basics that genealogists have been teaching for decades. I hope that answers your question.
Can I, do you have more to add?
Yeah, I just wanted to underscore, this is what your study is going to end up with. We have the answers to your study right here. You're going to spend millions of taxpayer dollars if you pass this bill today, if you send this bill forward, millions of taxpayer dollars, 3 to 5 years to do what we already know the answer to. That's the first point. Second point is, with respect to the chair, and with respect to your question also, member behind me here, let's take the senator at her word that these bills what this bill wants to do is not going to stop any other bill that any of you want to do. Let's take her at her word for that. So let's say, members, that you want to do a bill next year for people who are descendants of those who were enslaved in this country. In your district, there are a group of residents who are descendants of those who were enslaved in this country. Let's say you want to do something for that group of people. How are you going to determine and find out who those people are? If your bill is not connected to Senator Weber's bill, then you could, in theory, create your own process for figuring out who is a descendant of someone who was enslaved in this country. And then you, member, you could have your own bill with your own process, and we could go on and on. If it is true that this bill is not linked to the other bills, that's even worse. It's even worse. If it is true that this bill is linked to the other bills, which a clear and common sense reading of that makes that clear, then everything you want to do for this group of residents will have to wait for this 3 to 5 year study. And guess what? At the end of the 3 to 5 year study, when you end up with this, what we already know, there's no requirement at all for the results of the study to be used. The bureau that picks this work up, the agency that picks this work up, could say, thanks for your 5 years, no thanks. We're going to do our own thing. Okay? So it is either the bill is linked and it stops and slows down what you want to do, or it's not linked and it's even worse.
Thank you.
Thank you so much.
I'm sorry.
Sorry, I think
I had one more thing to add. In the methodology that we teach, like we're talking about tracing ancestors back through just the federal records, just the federal census records, right? Back in, I think it was 2018, 2019, about 20, 25 genealogists, we came here to the Capitol during one of the events, I think it was for Juneteenth, and we researched the California Assembly members and the California Legislative Black Caucus members. They came down, I think it was in the basement, and we traced their ancestries back. So those that we were able to find on a 1900 census or an 1800 census, by the definitions defined by the task force, they all qualified for reparations. So why do we need the CSUs to do that? Thank you.
Just want to say
Thank you,
something.
Madam Chair.
Someone in my lineage was a part of the assembly at that time. And like I said before, we still don't have our lineage. So not everyone was able to be traced if that happened. I believe someone.
Thank you, Senator.
I didn't say that.
Sorry, Dr. Corey Jackson.
Mr. Tamaki, you were a part of the reparations task force, and obviously you sat through an enormous amount of time discussing this and hearing from the public. In your estimation, when it comes to this particular bill, do you believe that it is a logical step to take for the state to have a process so that members can then be able to be certified for their lineage, so then they can have access to the repair that the state has available at that time?
The task force took their role very seriously, knowing that the documentation processes, the analysis, the scholarship was something that had to be established for all time, not only for the present, but for posterity. So it ended in an 1,100-page report, 30 days of hearing testimony, hundreds of witnesses testified. And every fact that matters in that report is footnoted and it's authorized. But we did not have the time to take a deep dive into this and frankly, many other areas. In some of these things, we had 13 chapters just tracing the history from enslavement to racial terror, to segregation, to healthcare, to the wealth gap, and so on. Any one of those topics in terms of coming up with the details and the processes and the structure to ameliorate those harms, it would have been impossible to do in a 2-year period. And the determination of eligibility, and more to the point, setting up the processes so it would be fair, it would be credible, it would be based in scholarship. The task force did not have time to do it. We were moving through these areas very, very rapidly. Still, it took 2 years. And so we think that 437 fills in a missing processes, missing details to get this done. And it also has to stand up to public scrutiny, to attack, to criticisms. It will be looked upon by other states. California is doing this for the first time, folks. In 1968, there was a presidential commission called the Kerner Commission that began to trace the dots between the harm of enslavement to its present day outcomes. That tracing took all of 40 pages. This is an 1,100-page deep dive tome. We call it the Book of Truth in some ways because it reveals facts that have been long forgotten or buried. And everybody on the task force considered themselves very well read in American history. But I have to say, everybody learned something new, especially in California, where things occurred here that you'd only expect to have occurred in the South. And so the details of a processes, when you implement it and operationalize it and make it fair and make it standardized and uniform is needed. And so I think the process will welcome the input of genealogists. But to have the scholarship and the credibility of Cal State University and the other university systems behind it is very important to build credibility.
Thank you very much for that. And I want to thank our caucus chair for authoring one of our flagship priority bills this year. And certainly know the painstaking work it has taken to work on this language, to kind of think about it from a process standpoint. How do we set up the state as a whole to be able to go from identification to access to repair? And so I want to thank you for the work that you've done, and I would like to move this bill, Mr. Chair.
Thank you so much. We have a motion. Do we have a second?
Mr. Chair, I'm sorry.
I'm sorry. Okay, thank you so much. We have a motion second. I want to recognize my colleagues first.
Sure.
Vice Chair DeMaio.
Thank you, Mr. Chair. Full disclosure, I am absolutely dead set against reparations. I don't think that they're fair. I don't think that they're legal. That's what we're talking about here, right? We're setting the stage for determining who eventually would be eligible for reparations, right? That's why we're doing this research?
Yeah.
You're funding the
Well-
research? Okay. So we're spending $6 million to figure out who would get reparations. So I think we should probably first figure out some research on whether it is legal to give reparations. The member from the task force said you studied history. I hope you also studied constitutional decisions. This issue of reparations was decided by the U.S. Supreme Court in 1988 when President Ronald Reagan signed into law federal legislation providing reparations for individuals who were forcibly placed into camps during World War II, Japanese Americans, by President Roosevelt. The legislation was challenged as unconstitutional on one side, that it wasn't permissible. The other side were individuals who were descendants of individuals who were put in the camps, who said that they were left out and that they should be provided with funds because they descended from Japanese Americans in the camps. The U.S. Supreme Court established in 1988, and by the way, this court decision was not from a conservative court, it was from quite a balanced court, some would say a moderate Supreme Court, that reparations can be provided only to an individual who directly suffered the harm at the hands of the government. In this case, being forced into a camp is a decision of the US federal government, shamefully. The Supreme Court and lower courts also rejected claims by descendants for compensation because the descendants were not directly forced into the camps. Their ancestors were. How do you overcome clear Supreme Court case law that would prohibit reparations for descendants of slaves from the 1860s? And how would you respond to the argument some might be saying that this is all political theater, that you're getting people's hopes up that they're going to get money, and then when you're smacked with the law, the case law, the constitutional law, you get to blame a conservative Supreme Court? Is this all just like a expensive setup to that? Because I'd rather let people know, like, up front,
Yeah.
you're not getting reparations, you're not getting the money because it's not lawful under federal anti-discrimination laws. So how would you respond to that argument? I understand the opposition's argument as to it not going far enough. I actually think we should not even go down the road at this point, but how would you respond to those issues?
Yeah, thank you so much, Assemblymember DeMaio, for that question. You know, and I believe that that is actually a question, a debate for another bill at another time, because that's not necessarily what this bill is about. But if you are interested in understanding what the task force was actually tasked to do and what their recommendations basically were focused around, last year when we talked about it, I always recommended for the members to actually read the report, or at least the executive summary, to really understand the scope of their work. And so it's not just about repairing the harms of slavery, it's about repairing the harms of slavery and also the systemic discrimination that came afterwards, which was actually at the hands of the state of California. But again, that's not what this bill is about. And I know we are debating this bill, but I strongly, strongly would hope, if you haven't, that you at least read the executive summary of the Reparations Task Force. We have a member of the task force here. It was lots of hours and years and time put in, and it's actually a really, really good read. And I do know that you enjoy reading. I would strongly recommend that you read that, and then we can have that conversation about the merits of actually giving out money at another time. But I think once you read it, you'll understand that repairing the harm of slavery and systemic discrimination that has occurred afterwards is not just about giving out money. It touches every aspect of society, legislation that we here in California passed, and also the things that we continue to do today. So it's more than just cash, and that's something that I have stated. That is something that the California Legislative Black Caucus has stated. I understand that you are not for reparations, and I respect that opinion of yours. That's not necessarily what we're discussing today.
So I will let you know, I did read the report in full
Oh,
because
great.
I've actually been very critical of the report.
Oh.
The various elements that it said that we needed to pay out, various costs to taxpayers.
Well, it was much more than just that.
Understood.
Yeah.
But your bill actually does relate to reparations. It's not about the systemic racism because you're dealing with genealogy going all the way back to people who are actually enslaved. So you're actually confirming my point.
No, what this bill does is if there are in the future restorative things specific for those, whether it's funding, educational things, whatever it is, and you're stating that you deserve this or that you need this because of the harms that you and your ancestors have encountered, how can you prove that you are truly a descendant of American chattel slavery?
Right, and again, that's why I'm raising this constitutional question of why spend $6 million on something to develop a methodology to identify people who the Supreme Court will not allow you to do an education program or to give cash payments because it would be discriminatory. You would have to set up a program that would be available to all, not based upon a special class. That's what the Supreme Court has ruled. That's the whole notion of the 14th Amendment, which was equal protection under the law.
Well,
and that's so important that we not spend $6 million on a methodology to implement a program that on its face is flying in direct contrast to very clear constitutional case law. I'd also say on systemic racism, the Supreme Court has also weighed in on these arguments people have made about, well, there's institutionalized racism, it's systemic. Again, the Supreme Court has been very clear. The government has an obligation to identify an individual, a specific government action against the individual, and a specific level of damage for compensation. I'm not sure that there are many cases that could meet that standard, even if you do the systemic racism side. I raise this important little fact, and this challenge, this legal burden, because whether you like a decision of the Supreme Court or not, or whether you like the application of the 14th Amendment or not, it exists for equal protection under the law. There's a reason why we have this standard, because it's about fairness and equity for all. And I am concerned, to those of you who support reparations, I am concerned that you are a victim of fraud. I'm concerned that you're being told something by elected officials that's not true, that's not going to happen. And I think that you need to understand the constitutional case law that these ideas are up against. You may not like the constitutional case law, but it is there. And so I would really encourage, perhaps before we see something like this, I've seen bills. I'm right now arguing with Ledge Council on one of my bills. They say, well, there's a federal law that we have a little issue with. I'd like to see our legislative council do its job as it relates to clearly articulated case law from the Supreme Court saying this is probably not going to fly.
Thank you, Mr. DeMaio.
Before advancing it. So again, to the author of the bill, those are the reasons why I oppose.
Thank you.
And if we can bring forward programs that are more income-based, there are a number of ways to structure programs, but the concept of reparations on these issues seem to fly in the face of that constitutional decision.
All right, thank you, Mr. DeMaio. And I think some of these discussions can be also held in the Judiciary Committee as well. I know that's where it's going to go next. Gets out to. Senator, did you want to add to that?
Oh, well,
I did
Or
want to
Mr. Tamaki.
respond. I do know something about the 1988 Civil Liberties Act. I'm the son of my mother and father were incarcerated in Topaz concentration camp in Utah. And the case that you're referring to as a U.S. Supreme Court case, you've misstated it. That was a class action for damages. Ultimately, it was dismissed out for two reasons: sovereign immunity and being beyond the statute of limitations. The Supreme Court did not rule that descendants are not eligible for reparations. That was not the issue before it. The other thing, Member DeMaio, is there are precedents where there have been reparations provided to descendants. 1922, the town of Rosewood was wiped out. They called it a race riot at the time. It was a massacre. And anywhere between 27 to 150 people were killed. The state of Florida not only at least provided some recompense to the surviving victims, a few of them, but they also provided benefits to descendants. 9/11 is also an example where the government recognized that it was not just enough to provide compensation to surviving first responders, but also to descendants. And so this idea that it cannot be done is a misstatement. I would say, finally, in terms of what Senator Weber Pearson has stated, the harm is continuing. You've given basically kind of a species of the argument, it's too late. And this is all about slavery. It is not. It is about the continuing and cascading consequences that have haunted American society from 1865 right up to the 40s, the 50s, and into the 60s, where people were still struggling to have the right to vote. So I just wanted to say it is a continuing harm. It's not just about descendants, it's about people experiencing these real, very real disparities today.
Thank you so much. Any further questions or comments? Seeing none, Senator, would you like to close, please?
thank you. Really want to thank, again, the committee for hearing this bill. Want to thank all of those who came to speak in support and those who came to speak in opposition, and, the robust conversations that we have had around this very, very, very important bill. I will not belabor the point. This bill is not a study bill. It is not something that has already been determined. It is not something that the task force gave us a pathway to do. California, the CSU system is one of the best in the country. They are very well equipped and also based within the community with the relationships that we need to ensure that this will be done fair, just, with transparency, and in a timely fashion. And with that, I respectfully ask for an aye vote on SB 437. Thank you.
Thank you so much, Senator Dr. Weber Pearson, for bringing this important measure forward and for accepting the committee's amendments as outlined in page 5 of the analysis. As we heard, the task force report has provided several policy proposals, and I believe this measure is a step in the right direction as it seeks to fully understand and determine lineage, which we know is a very complex issue. Thank you so much, Senator Weber Pearson, for your leadership and efforts, and I'm pleased to support this measure today. The motion before us is to pass as amended to the Judiciary Committee. Madam Secretary, roll call, please.
File item number 1, SB 437. The motion is due pass as amended to the Judiciary Committee. Fong.
Aye.
Fong, aye. DeMaio. No. DeMaio, no. No. Berner. Jeff Gonzalez. No. Jeff Gonzalez, no. Jackson. Aye. Jackson, aye. Marsucci. Patel. Celeste Rodriguez. Sharp Collins. Sharp Collins, aye. Tongipa. Tongipa, no.
That measures 3 ayes, 3 noes, and we'll keep the roll open for additional members add on. Thank you so much.
Oh, thank you, brother. I appreciate it. Hey, they work for- they work for-
Thank you so much. Next up is item number 9 by Senator Cabaldon, SB 790. Welcome, Senator Cabaldon.
way it currently stands, forced labor, slavery takes precedence over rehabilitation and public safety.
Oh, by the way, while the Biden administration gives reparations to everyone but free people, look at the billions he has run over to Ukraine.
We don't have black grocery stores because if you think about it now, just to get in that supply chain, it's almost unheard of.
They don't want the truth to get out. Okay? I don't want to know what my family did or what all these people did and all this stuff like that. Okay? You read that 500-page report.
There's this thing called white superiority and black inferiority. That mindset allows all of the behaviors that we've seen across generations, allows for the construction of these policies and practices and systems and structures that continue to oppress us. This is not a handout. This is a debt that is owed.
You know, Allensworth was like the internet of his time in 1904, 1905.
The total black population in California is about 2.6 million, and then of that, the descendants compose about 2.2 million of that. So California, with a multi-billion-dollar surplus, can absolutely afford to satisfy the international terms for reparations, beginning with compensation.
Any financial obstacle that exists that impedes the success of increasing financial prosperity needs to be dealt with and eliminated.
No matter where we've been, no matter what part of this fight we've been in, we've been harmed, and we've had harm done to us specifically.
When I got to Los Angeles, this was some of the worst segregation I'd ever seen. And remember, I'm telling you, I'm from Mississippi.
Because as you can see, I'm giving you broken history right now, you know? But I had to give it to you guys today. I said, no, I got to show them this because it's so precious and nobody really knows about it.
Black people don't have that kind of luxury. Our historically black communities have been redistricted multiple times.
Now listen, if you can't handle the TR roof, don't tune in.